First of all, Mr. McDaniel, let me congratulate you on being selected for a profile, a feature story in Attorney at Law magazine.
Thank you very much. I appreciate it very much.
There are over 15,000 attorneys in the state, and with a monthly magazine, we can only profile just a very, very small portion. And I'm very excited to meet with you and work on the interview for the magazine.
Ken, it's a pleasure. Thank you very much.
The first question I really want to ask you is a little bit of a personal background. You know, what did you do before you started your career as an attorney?
I did everything, and I did everything wrong. For instance, my undergraduate degree was in philosophy. Do you know what jobs are available when you have a philosophy degree? Well, as it turns out, none. On the other hand, because I was persistent, I was able to find a great job digging ditches in the hot, hot sun. Now, digging ditches in Arizona is kind of a specialty area all of its own, because this hand is going to become numb from the vibration. This hand is going to develop a glove because of the friction associated with the use of the pick. And by the way, the pick is a skilled tool. A shovel, not so much. But to use a pick properly takes a certain amount of practice and education. On the other hand, when you hit a patch of caliche, when you are digging ditches in Arizona in the hot, hot sun, it looks like a Roadrunner cartoon, because the pick goes, and so does your hand, and after a while, you can juggle charcoal briquettes after they've been burning for a while and not notice, just because you know it's a little rough on your hands. After a while digging ditches, I decided that maybe God had not designed me well for that. My back isn't strong enough, my hands actually have nerve endings in them, so I decided to do something so that I could work inside where it was air conditioned. At first, I didn't particularly care what I was going to do. I just wanted to go back to school so I could, you know, sit in a nice air conditioned room where I wasn't breathing dirt that I had ginned out myself with my pick and my Irish teaspoon. After that, I went back to law school. Law school was interesting. In law school, I thought I was working pretty hard. In law school, they want you to read an awful lot of material. So I read what I thought was a lot of material. Then I started working for the bankruptcy judges after law school, and I discovered what a lot of material really was.
Tell me about that path. You finished law school here at Arizona State University?
I did indeed. It's an excellent school.
And then you went to work in the bankruptcy court system?
I did. Initially, during my third year of law school, I had been asked to participate in the scrivening committee that generated the first bundle of local rules of court for the District of Arizona Bankruptcy Court. If it sounds like I'm proud of that, I'm inordinately proud of that. I did that as a law student. Now, have people done it afterwards and done a better job? Well, of course. But I was pleased, proud, and extraordinarily happy that I was chosen for that particular slot. After spending my third year studying essentially nothing but creditor, debtor, and bankruptcy classes, I was permitted to go to work at the bankruptcy court as a bankruptcy law clerk. Initially, I worked for bankruptcy judge Vincent Majori, and then I went to work for Chief Bankruptcy Judge Caldwell. Both of them had a tremendous knowledge of bankruptcy law, and they were inordinately helpful to me in learning that law. When I went to talk to old Judge Caldwell, who was not young when I went to work for him, and who knew every aspect of bankruptcy law, inside, outside, and sideways, he would ask me questions. I would come back with answers. He would say, I already have a better opinion than you do. I have my opinion. What I want you to do is to find the law. And I would say, yes, sir, because we had a very warm, informal relationship. And then I would scamper off, find him the law, and he was happy. That was an incredibly valuable experience for me, even though I was working 12 hours a day, 6 days a week, and one day a month, When it was Chapter 13 day the next day, I would spend the night at the bankruptcy court with a pocket calculator, figuring out which cases ought to be confirmed. It was similar when we had a gigantic Chapter 11 that was coming up for confirmation, because I would do both pocket calculator work and other kinds of analysis to give the judge my opinion. Now, to be perfectly fair, bankruptcy judges have very good opinions. They have their own. But bankruptcy law clerks are useful for collating data, going out and researching, and going through the pleadings to see if there are any arguments that are interesting or unusual in this case.
Well, that must give you just a tremendous amount of insight and angle into bankruptcy law that a lot of bankruptcy attorneys just couldn't have unless they worked on that inside.
I'm the luckiest guy in the world. I get to work in an area of the law that I love because it gives people a fresh start. I get to fix impossible to fix problems and get people out the other end of the car wash so that they can get on with their lives. Just so you know, the average self-made American millionaire goes broke 4 different times. It's necessary to get that self-made millionaire cleaned up, back out in the entrepreneur field so that he can generate jobs for other people. That's the way ultimately we're going to come out of this depression. But yeah, the background that I had was very, very fortunate. And by the same token, there are other very good bankruptcy attorneys in Phoenix.
Now, you obviously started your own firm after your schooling and law school, and you're clerking for the bankruptcy clerks. All you do here at your firm is bankruptcy. I know a lot of firms do practice a number of different areas of law, but you just do bankruptcy here?
That is an absolutely true statement. I am a one-trick pony. And the reason I went into practice initially was twofold. On the one hand, I discovered that I hated interviews much, much more than I hated digging ditches in the hard, hard ground, in the hot, hot sun in the summer in Arizona. And I discovered that it was possible to open a law practice right after you're done with specialized training from bankruptcy judges. And I was too stupid to know that I couldn't do it. If you don't know something's impossible, you just do it, kind of the way a bumblebee flies.
There probably isn't any typical client that you have here with your firm. Do you deal with individual clients, with corporations, or pretty much everybody that may have a need for this type of financial solution?
Yes. It is exactly true to say that there is no typical client. My clients include doctors, they include lawyers, they include CPAs, they include waitresses, they include nurses, they include real estate brokers and real estate salesmen who, because of the cyclical nature of the economy, may have to go bankrupt twice before they get it right. There is exactly no ordinary client for me.
You've been doing this for so many years. I mean, how many clients do you think you've had just off the wall?
I can't calculate it. I filed hundreds of Chapter 7s and Chapter 13s, and probably thousands, but they're all different. They all have different texture. They all have different situations. In any given bankruptcy case, let's look at a consumer Chapter 7, for instance. And that's a very, very useful tool, even though it's been blunted by the 2005 amendments. If you're looking at a consumer Chapter 7 bankruptcy, what you want is to optimize the case. You'd like the client to be able to keep all of the stuff they have, and you'd like them to be able to get rid of all of the debt. Optimizing for that equation is surprisingly complex. It's unusual in a difficult case to get a perfect result. What you want to do is to get as close to a perfect result as you can.
Excellent. Now, what do you think a person should do if they are considering bankruptcy? I mean, there are so many different types of bankruptcy. It's just mind-boggling for somebody outside of your profession to kind of look in. I mean, is it just an initial consultation? Do you jump in with both feet? What would you recommend?
It depends. Many people have told me that the amount of information associated with bankruptcy cases is simply overwhelming. And I find that easy to understand. I built a bankruptcy blog. In fact, I've built several specifically designed to educate, well, my potential clients and everybody else on the planet about bankruptcy law and the way it actually works. Because just knowing the law isn't good enough. Just knowing the rules, that's not good enough. You have to know the way those are applied in the area where you're practicing. There are multiple individuals who have an effect on any given bankruptcy case. There are judges. There are also bankruptcy trustees. There are 18 panel trustees in Maricopa County. They all have very different approaches to dealing with bankruptcy cases. One recently, at a first meeting of creditors, took a $1,000 check that my client had shipped over to him and handed it back to my client, who immediately burst into tears. Now, mind you, that's an extraordinarily unusual result in a case. But again, many of my cases are extraordinarily unusual.
Mr. McDaniel, let me ask you this. You've worked with hundreds and hundreds of different clients over the years that you've been practicing bankruptcy. Is there one case that really stands out as something that was just so gratifying when it came to conclusion?
There are several. One surprised me. I had a client who had inadvisedly entered into a stipulated judgment when he was quite young. It was a $5 million fraud judgment, and it was held by a governmental entity. Their position was that because of something like the size of a typeface that he'd used, that he had committed consumer fraud. He got older and needed to get on with his life and became quite successful. But that $5 million judgment looming in the background was always a source of concern to him. This was a guy who had a lot of different lawyers, and he was a smart cookie. So he talked to a lot of different lawyers, and they all gave him a lot of different suggestions, many of which were excellent suggestions. When he talked to me, I said, well, let me see what I can do about it. Ultimately, we decided that I was going to offer them $5,000 to settle the $5 million fraud judgment that was now non-appealable. So I picked up the phone and I said, hi, my name is Joe McDaniel. I'm an Arizona bankruptcy lawyer, and I've been talking to this guy about bankruptcy. And he really doesn't want to file, and he really wants to do the right thing. But obviously he has limited resources because, after all, he can't get on with his life because there's a $5 million fraud judgment hanging over his head like the sword of Damocles. On the other hand, he's able to borrow $5,000 from a family member. Do you suppose that would wrap up this deal? And the nice attorney on the other end of the phone said, I don't know, let me find out. He hung up. This guy's normal, ordinary course of business lawyer had bet me that this was the stupidest fool's errand known to mankind. So after I got the call back that said, sure, send over the check, we'll send you a release, I was able to get a free lunch that day. And that was pretty gratifying.
That's a pretty good. That's a pretty good day. Sometimes it's the simplest angle that is the right angle, huh?
Absolutely correct. Sometimes the magic works. In another case, I have a lot of clients who become friends. I had a business client who had a problem with 4 very angry banks. When people are angry, they can't think straight. When they're thinking out of the lizard portion of their brain, you know, the part that's been around for billions of years of evolution, all they can think about is winning. They want to win. They want to dominate the situation. That's fine. I understand that. It is impossible to negotiate with somebody when he's very, very angry because he can't do simple arithmetic. Fortunately, I have an actual superpower. If you look me up on the internet, you'll see me in the Guinness Book of World Records, or at least in my AVO profile, in which I say for all the world to hear that I am the world's most boring human being. And it's true. I got to sit with 4 very, very angry bankers in a small room with bad air circulation. I made sure that I had several boxes of donuts there because, you know, when your sugar stuff is going googly, you want to take a nap. After 3 or 4 hours, they were really bored. And I know that at least 2 of them signed the stipulation that I'd put together without bothering to read it. Being very boring is a very useful forensic ability. I didn't used to think it would come in handy. I used to want to be able to, I don't know, fly, have super strength, x-ray vision, any of that stuff when I was reading comic books when I was a kid. Turns out that the superpower that I got is exactly the correct superpower to help my clients.
Yeah, I love that story. That's wonderful. You talk to so many different people. I know that everybody has a different story, a different situation. Oh gosh, you probably get calls all the time. When does somebody know that this is the right path for them to take?
They don't. They have to go through the multiple stages of suffering, of resignation, of grief, before they can reach this conclusion. Now, with some people, it's much harder. With older professional people, with folks who have owned their own businesses and kept those businesses alive during good times and bad, reaching the conclusion that they just can't do it anymore. That's a hard conclusion to reach. With guys who've run their own business and kept everybody in their family employed for a period of 20 years, I even see physical symptoms. Migraines, sleepless nights, digestive upsets. People suffer before they come to a point where they have a moment of clarity. That moment of clarity may be when they get bored enough or tired enough or sad enough that they drift out of their lizard brain, which is saying, eek, 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 they're chasing me, okay? When you're terrified that somebody is chasing you and you're getting 100 phone calls, you can't use a pocket calculator, okay? This part of your brain is engaged, this part isn't. One of the things that I'm fortunately able to do with some clients is bore them enough that they can use a pocket calculator. Some folks walk into my office and bankruptcy is a bad option for them. If they're making $60,000 a year and they have $20,000 in credit card debt, bankruptcy is probably not a very good idea, assuming that this, that, and the other is equal. If somebody walks into my office and has $60,000 a year in income and $20 million in debt, secured and unsecured, one of the first things they say, and I get sort of a kick out of it, is, listen, I don't want to make any decisions today. I just want to look at my various options. And I like it when somebody asks me what their options are, and they're making $60,000 a year, and they owe $20 million. Because the decision tree on that set of options doesn't branch. There are limited options for that individual, if he or she wants to get on with his life.
Mr. McDaniel, let me ask you this just bluntly. What are your credentials as a bankruptcy attorney?
Ken, I have more credentials than a dog has fleas. If anybody wants to take the Pepsi challenge for bankruptcy lawyers, all they have to do is look me up on the internet. Okay, board certification, AVO rating of 10, Martindale-Hubbell rating of AV, former chairman of the State Bar Bankruptcy Section, former chairman of the American Bar Association Bankruptcy Committee of the General Practice Section, former editor of the American Bar Association Bankruptcy Update, and a partridge in a pear tree. But frankly, none of that matters. It really doesn't matter. Clients don't care what your credentials are. I heard somebody use a phrase, nobody cares how much you know until they know how much you care. Well, I'm not St. Francis of Assisi. I'm a guy. I used to dig ditches. Now I run a car wash. I have clients come in, they have horrible problems. I run them through the bankruptcy car wash. They come out on the other side clean, or as clean as I can make them. And that's my goal. Now, some people absolutely are horrible candidates for bankruptcy. I tell them that. I tell them, save yourself. Do not file a bankruptcy under any circumstances because blah, 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 blah. Others are bad candidates for this kind of bankruptcy, but good candidates for this one. I talked to a guy last night, and he was the first person I've seen in 6 months who I thought was a perfect candidate for a personal Chapter 11 bankruptcy. He was an unusual case. There are several kinds of bankruptcies. No need to talk about them. There's an overwhelming amount of information about them all over, including the internet, including books on Amazon. Read everything. Drill down through the information. Compare credentials. Like I said, having credentials doesn't mean, oh heck, doesn't mean a lot except that you've got credentials. Each of the credentials is different. What you have to have is an attorney who's done this before, who knows how the story ends, and who you trust some.
I can see that you humbly want to downplay some of your credentials, and you're right. A lot of people may not put a lot of stock in it, and that might be because they don't understand what they are. I'm one of those people. Just indulge me for a moment and go over maybe 2 or 3 of these. What does certified mean?
Board certification is a credential given by the State Bar of Arizona through the board that handles specialization. There are several sorts of specialization, board certification, granted in Arizona under the auspices of the State Bar of Arizona. There are, the last time I checked, approximately 28 board certified bankruptcy specialists in the state of Arizona.
So 28 out of every attorney that is practicing
28 out of about 6,000. Pardon me. 28 out of about 16,000 attorneys in Arizona are board certified in bankruptcy law.
Amazing.
Now, mind you, most of those won't touch certain kinds of cases. That is, I have restricted my practice at this time to debtor representation. However, several board certified bankruptcy attorneys work primarily for bankruptcy trustees, the natural enemy of debtors. Several represent only creditors, the really natural enemies of debtor. So out of that 28 board certified bankruptcy specialists in Arizona, some are perfectly willing to take debtor representation.
Wow. You mentioned some other specializations and certifications. Could you elaborate on those too?
Well,
when we discussed your credentials.
I'm very proud of my Martindale-Hubbell AV rating. That's a peer review rating. You can't buy it. Frankly, what happens is that Martindale-Hubbell sends out secret, that is to say, secret, confidential rating forms to selected attorneys in the state of Arizona, and they decide who gets a rating at all, and if they get a rating, what rating they get. I'm proud of that one because there was nothing I could do to influence it. One morning I woke up and I had an AV rating, and I was happy about that. The A rating stands for preeminent. The V portion of the rating has to do with ethical standing. Martindale-Hubbell doesn't give a rating to an attorney unless they have both the competence component and the ethics component. Most attorneys are not rated. Obviously, the largest number of rated attorneys are CV rated. A much smaller percentage of attorneys are BV rated, and those are very good attorneys. On the other hand, when I refer out to other attorneys for areas outside my specialization, I generally want to refer to an attorney who is AV rated, simply because, well, they're peer review rated and have gone through a sorting process that can't be bought. There's a newcomer to the attorney rating business. A website called avo.com rates attorneys based on another secret algorithm. The attorney claims a profile, puts in their experience, their school, their credentials, and a bunch of other information about them. It's a great site for consumers because it's easy to find, easy to sort. As a matter of fact, you can think of avo.com as sort of Amazon.com for lawyers, because you can sort them any number of different ways, including by client testimonials, including by physical proximity, and by AVO rating. The AVO rating typically runs from 5 to 10, 10 being the highest, well, 1 or 0, I suppose, being the lowest. Average attorneys show up in the middle of that range, and some attorneys, well, have a higher rating. I was delighted when I woke up one morning and AVO had awarded me a 10.0, and I was proud of it because I worked to do the best job I could for my clients for about 30 years.
Mr. McDaniel, let me ask you this question. I understand that practicing law is a business too, and specializing in bankruptcy law means you're dealing with people that don't have the best of finances. So how are the fees constructed for dealing with people that, in essence, may not have any money?
There is a sort of a joke. Actually, it is a joke. Here's the joke. Divorce attorney goes into a cocktail party, runs into a bankruptcy lawyer, says, you know, I've been wondering, how does a bankruptcy lawyer get paid? The bankruptcy lawyer answers, up front. Now, that joke conceals a certain amount of truth. As a practical matter, bankruptcy attorneys almost always need to get paid prior to filing their bankruptcy. And the reason for that is because they don't want their debt, that is, an obligation to be paid fees, to be discharged along with all the credit card debt and the mortgage debt and the car debt, because that would be silly. In general, if an attorney isn't smart enough to take care of himself, he may not be smart enough to take care of the client. Therefore, bankruptcy attorneys tend to take retainers. Abraham Lincoln said a retainer is how a client knows he has an attorney and an attorney knows that he has a client. Generally, I will accept payments in 2 or 3 payments. I don't take very extended payment streams from my clients for the incredibly simple reason that I used to. I'll tell you about that someday, but it doesn't work very well. In addition, the fact that folks can't pay their debts doesn't mean that they can't pay a bankruptcy attorney. And here's why. Someone who drops in to see a bankruptcy attorney may well have $50,000 or $200,000 worth of unsecured debt. That may require $5,000 worth of payments a month. They may have 10 investment homes that require big payments every month, and they can't pay those. But that doesn't mean that they're unable to pay an attorney to make the debt go away.
Once you decide that bankruptcy is the right path for a client that comes in to see you, I know that there are so many different avenues and angles. I mean, I've heard of Chapter 7, I've heard of Chapter 11, I've heard of Chapter 13. You know, what are the differences in all these different pursuits of resolution?
The answer to that question is a 2.5-day seminar. I only know that because that was the sort of topic that got discussed in 2.5-day seminars 30 years ago when I was either going to or pitching seminars in the area of bankruptcy law. I can give you some simple answers, but they're real simple and they don't come close to addressing the texture. A Chapter 7 is the kind of bankruptcy that most individuals want to file if they know what's going on. That's because it's only open for 1 to 3 years or 4 after the case is filed, and the client's involvement in the case is relatively minimal. I said relatively minimal after the case is filed. A Chapter 13 is only available to individuals, not to businesses, that is, not to corporations, partnerships, or LLCs. Only individuals need apply. It has debt limits. So you may be above the debt limit for a Chapter 13, but not pass the means test, so you're locked out of both 7 and 13. In some cases, that may kick you to a Chapter 11, but those are very seldom successful. The confirmation rate is low, and the success rate overall is quite low. About 83% of all bankruptcies filed in Maricopa County are Chapter 7 cases. Those are the cases that most people think about when they hear the word bankruptcy. There's a list of assets, some of which are exempt and the debtor gets to keep, some of which are over-encumbered, so the debtor gets to keep them. Some are worthless, so the debtor gets to keep them. And that means the debtor gets to keep all the stuff in approximately 96 to 97% of cases filed in Arizona. And then there are the debts in a Chapter 7. Some get discharged, that is scraped off, some do not. By the way, even though personal liability goes away in a Chapter 7 case for most but not all debts, the liens and mortgages and deeds of trust that are properly perfected pre-filing by creditors do not go away. So you can't, for instance, buy a car which has a lien on it in favor of the bank for $20,000 and file a bankruptcy, get a discharge, and then keep the car without paying for it. That would just be too easy. Chapter 13s are typically for people who cannot fit into or be made to fit into a Chapter 7 bankruptcy. And remember, not everybody qualifies for them because of certain debt limits located at 11 U.S.C. Section 108. Chapter 13s are a big fat pain in the neck. I mean, 7s are a big pain in the neck. Chapter 13s are gigantic pains in the neck. The legal fees are higher, but that's not the important pain in the neck. Although I understand that some folks try and push clients in that direction because the legal fees are higher. But the client is trapped in a payment scheme for 3 to 5 years. That's a huge price to pay for what used to be an easily available discharge. Nonetheless, it's sometimes necessary. I try hard to find every way I can to qualify a client for a Chapter 7 if I possibly can. Most of the benefits of a Chapter 13, for instance, prior to the 2005 amendments, there was something called the super discharge. Under the super discharge, even a debtor who was a little dishonest, or even a lot dishonest, as long as he qualified for a 13 and made his payments under the plan, could get a discharge. It was a super discharge. Somebody who had embezzled money, explicitly admitted embezzling money, could go through that process and get a discharge. And I only know that because I had a client who did. Most clients, by the way, are impeccably honest. Even he was once he had filed his bankruptcy. He just had a little problem prior to filing. By the way, there's a myth that there's a lot of bankruptcy abuse. There's a myth that some people don't list their assets. There's a myth that they, for some sneaky purpose, don't list their creditors. The reality is, most people hate the concept that they're going to have to file any kind of bankruptcy. Most of them agonize over trying to get their schedules accurate, true, and complete. It's not an easy process. But now I'm going to give you an actual answer to the sort of question you asked. The toolbox that we can work with after 2005 is the same toolbox, but the funnels have changed a little. Some folks won't fit into the funnel that permits people to file a Chapter 7. Some will and won't fit into a Chapter 13, which if you gotta use it, you gotta use it, but it's painful. From 3 to 5 years worth of painful payments made every month to a trustee. Chapter 11s, which are typically for publicly traded businesses, rock stars, and now may include some very few individuals who can't do either one of these, but it's still a truly troublesome postgraduate kind of bankruptcy, and Chapter 12s for family farmers and family fishermen. I've filed some Chapter 12s, not for family fishermen. This is a desert, but that's the toolbox. Figuring out which of those slots a debtor would fit into, or whether they require negotiating with one creditor, that's really the decision tree that takes a certain amount of thought.
You know, we've talked a lot about individuals. Does your firm help small business owners or companies if they need to file bankruptcy?
Yes. Historically, I've filed bankruptcies in small, medium, and gigantic cases. These days, for a number of reasons, most of the cases that I'm filing are consumer cases and small to medium-sized business cases. I have found some tools that seem to work reasonably well for helping individuals hold on to their small businesses when they file various sorts of bankruptcies. That is a postgraduate topic, and it is absolutely a case-by-case analysis. On the other hand, that's true of even individuals after the 2005 amendments.
What are some of the most common misconceptions people have about bankruptcy?
There are a number. The most common, and the one that makes me the most sad, crops up every time I'm a guest on a radio or TV show and people call in with questions. Somebody inevitably calls in and says, if I get sick and I can't make my payments to the bank, they're not able to take my house because it's my homestead, right? And I have to say, wrong. And I hate telling people that they're wrong, but of course that's wrong as it can be. There is a moderately generous homestead exemption here in Arizona for people who qualify to use the Arizona exemptions. It's generally up to $150,000, but in some cases there's a federal cap of $125,000. On the other hand, the homestead is effective against unsecured creditors and non-consensual creditors, and under some circumstances, judgment creditors, but it's utterly ineffective as a defense against a bank that has a mortgage. The homestead exemption has no ability to protect a homeowner who doesn't make payments on the mortgage. Eventually, the mortgage holder gets cranky and starts a trustee's sale. Typically, it's the first mortgage holder because the second mortgage holder is entirely underwater. They oftentimes don't start a trustee sale, they'll just sue the individual on the note, which they have a right to do. The first mortgage holder, however, starts a trustee sale, oftentimes when the third mortgage payment is missed, that is, when they're 90 days out. And the trustee sale process in Arizona takes 90 days from start to finish, unless it's interrupted by a bankruptcy case, in which case that'll stretch it out a little bit longer. But, yep, that's the most common misconception. It's not the only misconception.
Well, let me ask you another question. If somebody files bankruptcy, or they come to you and you decide that bankruptcy is the right course and the process is started, how quickly does that get the creditors, for lack of a better word, off their back?
That's a really good question. I have a pretty good answer, but not a perfect answer. Here's how it works. When a debtor files a bankruptcy, which remember might be 7 months or a year after they hire a competent bankruptcy attorney, because it may take a while to get them to the point that they pass the means test. And that's what, in my opinion, a capable bankruptcy attorney is going to try and do for any consumer client and some business clients for various reasons that we may discuss someday. That means that they're sort of twisting in the wind for 7 months or a year prior to a filing. That sounds really scary, and it is. During that time period, under the law, a creditor can call and say, how about you send some money to me? And they do. The large credit card companies and banks actually call about once a day until they get the result that they want. And that drives most poor consumer debtors out of their minds. On the other hand, the guys actually doing the collection calls, they don't want to waste their time. So if the collector makes a call and the debtor says, I'm going to file a bankruptcy, the collector says, great, I'm going to keep calling you every single day until you tell me that you have hired bankruptcy counsel and bankruptcy counsel confirms representation. That means that there are even some days when my switchboard is jammed. Here's how that works. If I'm hired by a bankruptcy debtor and we have to keep them semi-tranquilized and semi-out of the soup for a year, they will get 20 phone calls on any given day from a bunch of credit card collectors. They then give the name and number of my firm over to the collector. The collector then makes a phone call and says, hey, you representing Ed Schmidlap? One of my guys on the phone, either Steve or Sean, then looks on the database of our clients and says, Ed Schmidlap, yeah, they're one of my clients. The guy who's doing the collections then says, oh, okay, well, so much for that, because the collector doesn't want to waste his time making phone calls where he knows he won't get paid. However, a lot of people will say the B word long before they're really going to file. And they say the B word long before they've hired an attorney. Once they hire counsel, the collector knows they're going to file. It may take them a while, and in the case of my clients, it may take them quite a while. However, now they mostly don't call. Will they still call? Sometimes they will. But 95% of the phone calls stop, and sometimes 100% of the phone calls stop. On the other hand, depending on the length of time that the client has to wait until they qualify, and waiting to qualify is painful, but the alternative is going to be a 5-year payment plan. So some amount of torment, purgatory before heaven, may very well be a good thing, as opposed to, say, an immediate cessation of pain and 5 years of very substantial purgatory. As a result, they may be outside of a bankruptcy filing, and some credit card company may decide to sue them. That sounds scary, and it is. In fact, the first time somebody gets sued in their life, they go a little crazy. They become disoriented, and they experience deer in the headlights syndrome. They have a tendency to take the lawsuit that they've been served with, run into the bedroom, open the chest of drawers, jam it in, close it, and go, okay, that's done. That's the wrong thing to do. The right thing to do is to get an answer filed, because just filing an answer puts off the date that a judgment will hit probably 3 to 6 months. Now, that is a relatively complex topic, and in some cases, as crazy as this sounds, a creditor who sues one of my clients may be the client's best friend. Are you mad? Probably, but I may still be right. Here's how that works. Let's suppose a client of mine doesn't pass the means test. It could happen, because I have very good quality bankruptcy clients by and large. Let's suppose they're sued and the creditor gets a judgment. Okay. Now the creditor starts to garnish their wages. In Arizona, unless you ask for a hardship reduction, a garnishment reduces the net that goes to the debtor by 25%. Now, that means that over the passage of a certain amount of time, the debtor may now pass the means test. So the worst enemy is magically transmogrified into the best friend. Is that a great technique? It's not a perfect technique. It's not easy, it's not fun, but it's one of the tools in the toolbox that may be useful after the 2005 amendments.